Breaking news out of the state of California and the United States Supreme Court. We're going to cover two cases and how they're actually interrelated in an important way that no one else has connected the dots on, but I have. Specifically, I want to talk about this huge win by the California Rifle and Pistol Association, the Second Amendment Foundation, and of course the Gun Owners of America. We love them all, among other plaintiffs, involving the right of Americans who do not live in California to be able to apply and get concealed carry permits in the state of California from California, and how this all ties in to a just released Supreme Court decision on a preliminary injunction dealing with a corporate transparency law. How does all this work, and how does this make you the smartest person in the room? You'll find out when you stay tuned. We'll be right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the 2025 Gun News Award winner for the top voices of the Second Amendment. I'm proud of that win, and I owe it all to you out there who show support for this channel and voted for me for the top voice of the Second Amendment in the Gun News Awards. Thank you for that. Okay, folks, so this is the tale of two cases given rise to a big theme that you need to understand what's coming, because it's going to be a big deal and a very good positive development in favor of the Donald Trump policies, which will include pro-Second Amendment efforts. Okay, so to begin with, let me start with the great news out of the state of California. In a case that was brought by the California Rifle and Pistol Association, the Gun Owners of America, and the Second Amendment Foundation, among others, sued California on behalf of non-resident, meaning Americans that do not live in California. They were sued, the state of California was sued on the grounds that those non-residents were not legally allowed under state law to apply to concealed carry in California. Well, I'm happy to report that the United States District Court for the Central District of California entered an injunction, a preliminary injunction, that has just been reaffirmed with a specific order that does indeed allow a process whereby non-Californians may apply to get their concealed carry permit to concealed carry handguns in the state of California. So this is a big litigation win for the Second Amendment. So congratulations to the Gun Owners of America, the Second Amendment Foundation, and the California Rifle and Pistol Association. Now, I want to read one aspect of this order from the judge in California, and then I'm going to tie that in to a Supreme Court decision that just was released dealing with a Corporate Transparency Act. So specifically, before we get to that Supreme Court decision that was just decided, literally just decided, I want to read you the relevant language from this California case on behalf of the California Rifle and Pistol Association that was a party and represented people from across the country that want to apply for concealed carry licenses in California, but were not able to do so up until now. Listen to this language carefully, and then we'll talk about why it's important and significant in many ways. This court, having reviewed the proposed order, accordingly orders as to defendant Bonta, who of course is, the Attorney General of the state of California, orders as to defendant Bonta, the Attorney General of California, that residents of states and U.S. territories besides California, listen carefully, folks, this is important, who are members of the California Rifle and Pistol Association, Gun Owners of America, Gun Owners of California, or the Second Amendment Foundation, and who are not otherwise prohibited from possessing firearms under federal or California law, upon proof of such membership, are entitled under this order to apply for a California concealed handgun license as provided for under penal code sections, etc., etc. So that's great news. Congratulations. Big win for the Second Amendment. Now, why did I read you that language that says, in addition to not being a prohibited person under federal law or California law, you also had to be a member of one of those gun rights organizations in order to benefit from this order. Now, if you're not a member of one of those gun rights organizations, it doesn't appear that you can benefit from this order in and of itself. I guess you can apply and join those memberships, those organizations, and get a membership in those organizations and then apply. But why am I emphasizing this point? Well, other than just to bring you this news, there's a particular reason why I think this order was drafted this way. And it has a bigger ramifications for you reading the newspaper, you reading the internet, on cases involving Donald Trump's efforts to restore America to greatness. Specifically, as you may recall, in the first Donald Trump administration from 2016, that's when he was elected, so 2017 through 2020, 2021, you probably remember a series of lawsuits that were commenced against the Trump administration on various issues. For example, Donald Trump would issue executive orders on immigration. There would be lawsuits brought, and then some judge in Hawaii or California or Washington or some random part of America, one of the hundreds and hundreds of district court judges, would enter in an order enjoining the president from effectuating and enforcing his federal law, his federal effort. These were called universal injunctions because even though one person, let's say in Washington state, would sue in front of one judge in Washington state or Hawaii, they would ask the federal court to enter an injunction against the President of the United States and the entire federal government, preventing the President and the entire federal government from enforcing that regulation, that rule, that executive order, whatever it happened to be, nationwide. So what you effectively had in the first term of the Trump administrations, and by the way, you're going to see where this is going now and why things that irritated us in the last few years are going to come back and pay dividends. Just give me 1 second to tie it all up. So during that first Trump administration, you would have situations where a single judge and a couple parties in a crazy anti-Trump jurisdiction, like Oregon, Washington, Hawaii, California, would enjoin Donald Trump and shut down the federal government's efforts to, let's say, protect the border, kick out illegal aliens, whatever. Stop people from coming into the United States that shouldn't be here, and so on and so on. The U.S. Supreme Court does not like this. They do not like universal injunctions where you have a single judge, a single district, enter an order that applies nationwide to the entire country. And obviously the reason why they don't like this is a matter of judicial efficiency, as a matter of good governance, whatever you want to call this, is they don't like the idea that one judge in America essentially has the same power as the President of the United States. It's kind of anti-democratic in a certain respect, right? That's a little D, democratic. So the Supreme Court in the last, so now let's fast forward to the Biden years, right? We saw the problem of universal injunctions with one judge messing up federal policy enacted by President Trump. So let's fast forward to the year 2021 through 2025, the Biden years. Now, there was a series of things that the Biden administration would do that we in the Second Amendment community would get angry about. And there would be lawsuits commenced over these issues, and the lower courts would enter injunctions with respect to many of these. Some of these went all the way up to the U.S. Supreme Court, where the lower courts had entered an injunction, sometimes using the Administrative Procedure Act with the order of vacatur. And the U.S. Supreme Court, even when they would ultimately rule in our favor, like in the Cargill case, dealing with declaring the bump stock ban to be illegal, even in that case, the Supreme Court refused to enjoin and refused to allow lower courts to enjoin the enforcement of those ultimately unconstitutional illegal laws. And what was going on here, as I explained this on videos before, was I was not happy that the Supreme Court was allowing these unconstitutional illegal laws to continue, and they weren't allowing lower courts to enjoin them. But I pointed out at the time that although we're not happy in the short run with those decisions of allowing illegal or likely illegal laws by the feds to continue on and not be enjoined until it got ultimately to the U.S. Supreme Court with a decision on the merits. The precedent that was being set, and listen carefully because you're going to see how it's going to play out in a minute. The precedents being set by the U.S. Supreme Court during the Biden years, even though there were many instances we were angry about it, is now going to pay off. It's now going to bear fruit. And how so? You see, the last 4 years have established very clear precedents that lower court, district court judges do not have the authority to enter, as a general matter, universal injunctions that basically enjoin the federal government from enforcing a particular law across the country, which means that a federal district court judge in Oregon, let's say, no longer has the authority to enter an injunction that will bind the federal government's offices all across America in places like Florida, Texas, New Hampshire, whatever. This precedent of one judge no longer able to shut down the law across the country was shut down and stopped, this sort of by virtue of series of precedents created by the U.S. Supreme Court during the Biden years. Now, why is this important? Because the precedent was set was twofold. Listen carefully. The first precedent that was set was, again, one judge cannot do a nationwide injunction that's universal in nature that applies to everyone in the country. Can't do that anymore. Number two, and this is a related corollary, a federal district court judge, if they want to do an injunction, can still do a preliminary injunction. That's still allowed. That's still kosher. That's okay. However, and this is listen carefully because it's going to tie in to what just happened in that California case I just described. However, a federal district court judge still has the authority to enter injunctive relief on behalf of the very specific people that are in front of him. The specific individual parties who have come to court in front of that judge can still earn and receive injunctive relief. So in this case involving non-residents who don't live in the state of California being able to apply to get a concealed carry permit, if you look at how the order is written, it doesn't say that everyone in America can now apply for a concealed carry permit in California. Instead, it's laser focused on if you are a member of one of the gun rights organizations that sued and is literally in front of that federal court and has literally won the case on a preliminary injunction basis at least. If you're a member of one of those organizations that's actually a party to the case, you get to benefit from the injunction. But that injunction by that federal district court judge in California doesn't extend to all Americans because not all Americans are in front of him. The only people in front of this judge are those organizations and a handful of other specific people. They benefit from the injunction. Now, the reason why all this stuff ties in is to this Supreme Court decision that just occurred literally right now in the case of McHenry versus Texas Top Cop Shop. Now, I'm not going to get into the details of this case in this video beyond to say the following, that this is a case that went down in Texas. The district court judge entered an injunction that said that this law called the Corporate Transparency Act or something like that, I think that's what it's actually called, the Corporate Transparency Act, which is a totally stupid, absurd, likely unconstitutional law. We'll get to that in another video. But the federal district court judge in the Fifth Circuit said that this law was likely unconstitutional, and because of that, they enjoined it, meaning saying that the federal government cannot enforce this law. The Attorney General of the United States then sought cert, or at least sought an injunction, or really what they sought is they wanted the Supreme Court to stay the injunction entered by the lower courts. And the Supreme Court just granted that stay, saying that the lower courts did not have the authority, for all intents and purposes, what they said, that the lower courts did not have the authority, or the lower courts should not enjoin this law at this time, and they stay the lower court injunction. Now, here's the interesting thing. Who dissented from that decision? Justice Ketanji Brown Jackson. Justice Ketanji Brown Jackson dissented from that, saying that she would have allowed the lower court injunction of that federal law to go into effect and to stay in effect, which applied to everyone in America. Why does liberal Ketanji Brown Jackson stand up for a lower court injunction being able to enjoin an entire federal law as applied to everyone in America? We know why. Because she sees what's coming down the chessboard with all these single judges in America are going to be trying to enjoin nationwide Donald Trump's policies. But I'm happy to report that as a general matter, because of the precedent set by the U.S. Supreme Court in the 4 years during the Biden administration, many of which we were angry about because it kind of hurt gun rights in the Second Amendment and boldened the ATF, at least temporarily. As you can see, that's not going to happen going forward. Those precedents, which we weren't happy about, will now be used to stop individual district court judges from going crazy and shutting down national policies enacted by the Trump administration. So the problems that we experienced in advancing and enacting the Trump administration's policies in 2016 through 2020 or so, we're not going to see that to the same degree right here and right now because of those precedents set during the Biden administration. And the fact that this district court ruling was drafted as described to apply only to those people that are members of those gun rights organizations that are literally before the court, as opposed to like all gun rights organizations and all Americans, really goes to show you that the effect of those Supreme Court rulings in the last 4 years is having an effect on limiting the powers of an individual federal judge, what ultimately is very good because we want that Trump agenda to be enacted, and it's going to pay off big time. You'll see. All right, folks, so there you have it. I hope it was helpful to connect some of these dots, both from the past, the future, and going forward, and congratulations to those gun rights groups in California for that big win out there in terms of non-residents being able to apply for concealed carry permits. So there you have it. Don't forget to follow me on X at 4boxofdowner. Make sure you subscribe to both Rumble and YouTube. We're trying to build up our base over there on Rumble because a lot of people prefer Rumble over YouTube. And again, thank you for tuning in, and I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.